All right, welcome to The Explainer. Today we are going to tackle a legal concept that's super powerful, but honestly pretty misunderstood. It's called abuse of discretion. We're going to break down what it is, how to spot it, and most importantly, what you can actually do about it when you see it happen in court. Let's dive in.
So let's start with a feeling. You're in a courtroom and the judge makes a decision that just feels completely off the rails. It's not just that you disagree, it feels fundamentally unreasonable. It's that moment where you're just thinking, wait, what? There's no way that can be right.
And you know that feeling of unfairness? It's a really powerful starting point. But here's the thing about the legal world. A feeling isn't enough. To really challenge a decision like that, you have to take that frustration and channel it into a real, structured argument. And for that, you need a specific legal tool.
And that tool, the name for that very specific type of unreasonable ruling, is the abuse of discretion standard. This is the key that unlocks the whole thing.
So what does that actually mean in plain English?
Well, think of it this way.
A judge usually has a range of perfectly acceptable choices they can make in a situation. An abuse of discretion is what happens when their decision falls completely outside of that acceptable range. It's not just a choice you happen to disagree with. It's a choice the law itself just doesn't allow. Here's a super simple way to picture it. The law might say a judge can pick option A or option B. Both are totally fine. That's their discretion. An abuse of discretion is when the judge just ignores A and B and goes way off script to pick option Z, a choice that just wasn't on the table to begin with.
Okay, so we know what it is, but how do you spot one in the wild? This is where we need to figure out the difference between a ruling you just don't like and one that's actually legally a reversible error.
And this is absolutely critical. Look at the column on the left. The judge believed the other side or weighed their evidence more heavily. These are common frustrations for sure, but they are really hard to challenge because that's part of a judge's job. But now look at the right. The judge excluded key evidence for a legally wrong reason or refused to let someone testify without a good basis. See the difference? These are the kinds of actions that can cross that line into a real legal error.
So let's drill down on that evidence point, because it's a big one. You have to ask yourself this key question. Did the judge exclude your evidence, as in they refused to even let it become part of the record, or did they discount it, meaning they let it in, listened to it, but just didn't find it very convincing? If it was excluded for the wrong reason, you might have something. But if they just discounted it, well, that's a much tougher hill to climb.
Okay, knowing the difference is one thing. But what do you actually do about it right there in the heat of the moment? Let's talk about the in-court action plan. Now, lean in for this part because it is absolutely 100% the make or break rule. A higher court and appeals court can ignore even the most obvious slam dunk error if you fail to do one simple thing in the moment. You must preserve the error for the record. If it's not in the record, it's like it never happened. And here's your playbook for doing just that. It's a three-step process. First, you have to object right away, and you have to be specific about why. Second, you need to get a clear ruling from the judge, sustained, overruled, whatever it is. And third, and this is the one people often forget, if your evidence gets blocked, you have to make what's called an offer of proof to explain exactly what that evidence would have shown.
The words you use really matter. Just yelling, "That's unfair," does absolutely nothing for you legally. It doesn't preserve a thing. You have to use the right language, like objection, relevance, or objection, this is improper hearsay. That puts the specific legal issue on the record so a higher court can actually review it later.
And this sentence right here, this might be one of the most powerful things you can say in court. When a judge shuts you down and says you can't present a piece of evidence, asking to make an offer of proof is your formal way of telling the appeal court, hey, listen up, here is the important evidence that the trial judge wouldn't let me show you. Without that, the appeal court has no idea if the error even mattered.
Okay, so you've spotted the error. You preserved it perfectly for the record. You're not done yet, though. There is one final major hurdle. You have to prove that the error actually mattered.
See, courts don't reverse cases for small, harmless errors. It's not enough to just say the judge messed up. You have to prove what's called prejudice, that the error was a game changer. And you do that by connecting the dots. You have to clearly explain, here's what was excluded, here's what it would have proven, here's the specific finding it would have changed, and ultimately, here's how it would have changed the final outcome of the entire case.
So let's wrap it all up with a final checklist. A really strong abuse of discretion argument isn't built on emotion or a general feeling of unfairness. It's a technical argument, and it's built on these 5 essential pieces: a specific ruling you can point to, a timely objection made right there in court, a clear ruling on the record, an offer of proof for anything that was excluded, and a clear, powerful explanation of why that error was prejudicial.
So, the whole point of this explainer isn't just to teach you some abstract legal theory. It's to give you a practical tool, a new lens to analyze what happened in a hearing or a trial. So the real question I want to leave you with is this. Now that you have this framework, which moment, which specific ruling, which piece of excluded evidence in your case might just deserve a second look?